I'm Amy Goodman. The U.S. Supreme Court appears poised to uphold Tennessee's ban on gender-affirming care for transgender youth after hearing arguments in a case that could have major repercussions for transgender people across the United States. The Biden administration and the American Civil Liberties Union argued against the ban, saying it's a form of sex discrimination. But Chief Justice John Roberts and other right-wing justices appeared to reject that argument. After the oral arguments, Tennessee Attorney General Jonathan Skrmetti spoke outside the Supreme Court.
The people of Tennessee, acting through a bipartisan supermajority of their elected officials, made a similar choice. They passed SB 1 to protect kids. Half the states in the United States have done the same. The Constitution allows the states to protect kids from unproven, life-altering procedures based on uncertain science. The states have exercised the power to regulate the practice of medicine for hundreds of years. The dramatic and unexplained increase in the use of these life-altering procedures on kids is exactly the sort of situation where the state should take notice and regulate. Now, adolescence is hard, and gender dysphoria is a heavy burden, and we need to remember that. But the evidence shows that the large majority of kids dealing with gender dysphoria will grow out of it unless they're put on these medications.
ACLU attorney Chase Strangio also spoke outside the Supreme Court shortly after making history as the first openly trans lawyer to argue before the Supreme Court.
And today we were able to stand before this court and say the Constitution protects trans people just like it protects everyone else. It is breaking no new ground to recognize that when you are prohibited from receiving something because of your sex, it is the role of the courts to ensure that the government can satisfy its burden of showing that it has a good reason for doing so. Tennessee did not meet their burden. This law, we believe, is unconstitutional. And perhaps the scariest thing for all of us is that Tennessee's arguments would apply if Congress tomorrow banned this care nationally. For adolescents, for adults, they claim that there are no protections based on sex for the transgender people who, like myself, who rely on this medical care.
That was ACLU attorney Chase Strangio, who argued before the Supreme Court. He'll join us live in a moment. But first, I want to turn to excerpts of Wednesday's oral arguments. This is Tennessee Solicitor General Matthew Rice, followed by liberal Justice Sonia Sotomayor.
Our position is that there is no sex-based classification, but to finish the answer, that to the extent that a law dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
So when you're 1% of the population, when you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
During the oral arguments, Justice Amy Coney Barrett, who was appointed to the Supreme Court by Donald Trump, asked if trans people have ever been discriminated against.
We just head-on confront the question which you raise in the second part of your brief about whether transgender status should be a suspect class. One question I have is, at least as far as I can think of, we don't have a history of de jure, or that I know of, we don't have a history of de jure discrimination against transgender people, right?
So I think you may be right that the discrimination, historical discrimination against transgender people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here, and it hasn't just been confined to private actors. I think that if you actually looked at the facts, there's a wealth of evidence to suggest that transgender people throughout history have been subjected to violence and discrimination and maybe lost employment opportunities or housing opportunities, even in contexts where there might be state public employment at play.
That was U.S. Solicitor General Elizabeth Prelogar responding to a question from Justice Amy Coney Barrett. Justice Ketanji Brown Jackson, who was appointed by Joe Biden, expressed concern that the court was moving to undermine the foundations of what she called bedrock equal protection cases. She cited the 1967 decision in Loving v. Virginia that struck down a state ban on interracial marriage.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
That was ACLU attorney Chase Strangio responding to Justice Ketanji Brown Jackson. Chase is co-director of the American Civil Liberties Union's LGBTQ and HIV project. On Wednesday, he became the first openly transgender lawyer to argue a case before the Supreme Court. Chase, however this turns out, you have made history. Can you talk first about just the experience of being in the Supreme Court? Describe the nut of this case and how you think it went. What were you most surprised by?
Well, thank you, Amy. It's good to be with you and to relive some of those moments, which when you're in it, you don't necessarily really internalize it as it's happening. And so I'm still replaying everything in my mind. I'll sort of speak first to what it felt like in the courtroom yesterday. And the first thing I'll say is that it was incredible to have so many advocates who have worked to defend trans people for so long. And of course, notably yesterday, we were defended by the United States through the Solicitor General, who was up at the lectern for over an hour answering questions about the straightforward claims that both the United States and the private plaintiffs represented by ACLU and Lambda Legal and Aiken Gump were making, which is that there is a sex-based classification in this law. It is very difficult to try to explain that away because on the face of the statute that Tennessee passed, they say you cannot have treatment when it's inconsistent with your sex. And I think one of the striking things about yesterday's argument is that the Solicitor General of Tennessee could not find his way out of that straightforward reality of the law that the Tennessee legislature passed that he was trying to defend on the ground that it was sex neutral. Now, all of the conversations in the argument about the alleged risks of the treatment and what's happening in Europe, none of that changes. First of all, it's completely distorted. But of course, none of that changes that Tennessee's law draws this sex-based classification. And that is what Justice Jackson was really trying to get at the end, is that we are not doing this analysis correctly, and she really refocused us on that point.